Miss Green, I just hit there you go.
Hi, good afternoon, Your Honor. This is Darius Torres. Good afternoon, Your Honor.
Oh, hello. You're not whom I expected to be. So, we can do that matter first. I guess, no, they are set at the same time. So, and Mr. Felicki, I know we need an interpreter. I see that Mr. Morocco has his daughter here. I don't know if she understands English, but I'd prefer her not to hear negative things.
Oh, certainly, Your Honor.
But I don't know what she can understand.
Certainly, Your Honor. I can go quickly talk to Mr.
Okay. Or we have the interpreter here and I can have him say that.
Oh, if that works better, Your Honor, I think, yeah, that'll be a little less.
All right, Mr. Torres, would you please ask Mr. Morocco if his daughter understands? We will go on the record in the matter 25 CM 47, State of Wisconsin versus Miguel Morocco.
Muy bien.
Morocco appears in person with his counsel, Joel Felicki. I'm going to swear him in right now. Torres, can you please raise your right hand and let me know when you have done so? Bring to the court here today that you are in fact a certified court reporter for this state or any other state or federal court. Formal training in interpreting, specifically legal interpreting. Today, authentically. Felicki, this matter was reaching a resolution with Mr. Morocco to do a diversion program.
That is correct, Your Honor.
Yes.
Has he completed that program?
Honor.
Victims' rights compliance?
Yes, Your Honor.
Mr. Schmidt, where are we with this matter now?
Amendment would call for an ordinance for DC.
Felicki, does he accept that offer?
To accept this offer, Your Honor.
Sí, Su Señoría.
To amend Mr. Schmidt.
Otorgado.
How does he wish to plead?
Como desea.
Yeah, gracias.
Thank you.
Thank you, Mr.
I will
Torres.
sit in.
We will go on the record in the matter 24 TR 1122 25 CM 30 State of Wisconsin versus Victoria Mott. This date appears through District Attorney Kevin Schmidt in person. Ms. Mott appears in person with counsel Joel Felicki. We're set here today in this matter for a final pretrial. That is the drop dead date for the court to proceed if you are going to have any type of resolution, or the matter will continue to trial. We have a trial date scheduled for August 20th. On that date and time, you're still at PO Box 77 Shell Lake?
Yes.
Okay, thank you. Mr. Felicki, can you please update the court?
Thank you, Your Honor. The parties have not reached an agreement in this matter. I have discussed this matter at length with Ms. Mott. I've reviewed the discovery with her as well as potential defenses and our overall trial strategy. So at this time, we are still ready to proceed with trial.
What is the offer that's been presented? I need to go over the offer with you, maximum possible penalties, any potential that could happen if found guilty at trial. I need to know that you are affirming on the record that you are not accepting any agreement, or if you wish to have a little bit of time to consider that. What is the offer, Mr. Felicki?
Thank you, Your Honor. The offer was to plead to one count of violating a harassment restraining order, dismiss and reading in the remaining charges along with the traffic ticket, with a joint recommendation for 1 year probation, costs, and no contact with the residences of Christy and Jason Haskins, or with the persons of Christy or Jason Haskins.
All right, and we are in victims' rights compliance?
Yes, Your Honor.
Okay, so Ms. Mott, I need to go over this offer with you so I can be assured that you fully understand the potentials of what could potentially happen or not happen, I guess, or happen. You are charged with 6 counts of violation of an injunction, of a harassment injunction. Each count alone, these allege multiple dates, which would be November 23rd, 2020, 4, 2 counts, January 1st, 2024, 2 counts, and September 16, 2023, 2 counts. If the matter goes to trial and you're found guilty on all of these counts or any of these counts, actually, there's a maximum possible penalty of $10,000 fine per count and up to 9 months of incarceration per count. Okay, so that means it could be, if found guilty of all of the charges, and again, there are 6 counts there, it could be a maximum possible penalty of 54 months of incarceration and $60,000 in fines. Okay, that's the maximum possible penalty. Right now, there is an offer to plead to 1 count, have counts 2 through 6 be dismissed and read in, meaning you can never be found guilty on those charges again, those 6 or those 5 charges, with a recommendation to the court of 1 year of probation and with what's called a withheld sentence, meaning it could be up to 9 months of incarceration. Is it free to argue, or is that the that's what you're asking for, is 1 year?
Yep.
But he's not free to argue. I just want to make sure I understand the offer.
I would be fine if they argued.
And so the state is saying that his recommendation to the court's 1 year probation. Defense can argue for anything that they wish for the court to consider, which could be a fine or up to 9 months of incarceration or probation or any of the alternative. Okay, so that is what the offer is. So do you completely understand the offer?
Yes, I do.
And with 6 counts, if found guilty on 6 counts or any number of the counts, the court may, not saying it will, if this goes to a jury trial, may revoke bond at that time, and you would sit in custody until sentencing. Okay, that's just a possibility, a potential. Again, I need to be assured you fully understand the offer, the stakes, and all of those things. The state has the burden to prove beyond a reasonable doubt that you are guilty of 1 or all of these counts. All right, that's the burden of the state. So you understand the offer, and now I need to know if you wish to reject that offer and if we're proceeding to a jury trial on August 20th, or if you want to have a little bit more time to talk to your attorney.
I would like to reject it and proceed with trial, please.
All right, so then on August 20th, we will go to trial. I believe it's only set for 1 day, if I'm recalling.
I think it's 2.
Is it
Your Honor.
2? Let me just double check.
I do have it on my calendar as 2 days, Your Honor.
I do have it as 2. You are correct. So a 2-day trial on August 20th. So Ms. Mott, so you can understand, the court will not accept any offer after today. Either you plead guilty to all 6 counts or the state dismisses those counts, but I will accept no offer after today. All right?
Yes, I understand.
Okay, so August 20th, be here 8 o'clock or earlier, depending on what your attorney wants. Mr. Schmidt.
There are 2 things we probably need to address today before we break from this final pretrial. First, one of the defendant's motions in limine, motion limine 15, asks the court to order exclusion of all recorded interviews and body camera footage without a pretrial hearing on it first. They've not requested anything specific. Is the defense trying to exclude any video?
My apologies, I'm just, I believe that's boilerplate, but I will confirm that shortly. I apologize. I am just looking up the motions that I filed.
Yes, it says that the state be prohibited from playing any recorded interviews or body camera footage without a pretrial hearing on the admissibility of the contents of each recording and appropriate editing and or transcription to remove any and all inadmissible and or incomprehensible material, including but not limited to any interviewer's opinions regarding the truthfulness of the allegations. and it gives the Wisconsin statute.
I see. Yeah, yes, Your Honor, that was boilerplate language.
Okay.
All right, so that is stricken.
So the second concern I had is I just want to, no witness list has been filed. We are past the deadline for notice of alibi. There's been no Denny motion. So I just want to make sure it's understood that there are certain defenses not available to the defendant at this trial. If this were the original goal, the defense is being alibi. That is, I wasn't there, I was somewhere else, or third party perpetrator Denny, it wasn't me, it was someone else. I just wanted to make sure, because those have very specific requirements if you wanted to raise those. That is all.
So, Ms. Mott, do you understand that? I don't know your defenses, and I'm not asking you to tell me your defenses, but you understand that no alibi has been filed in this case.
Yes, I understand.
And with regards to witness list, today is the deadline. So then the only ability would be for your attorney to cross-examine the state's witnesses and or for you to testify. You understand?
I understand.
All right. Anything further, Mr. Schmidt?
I don't know if I addressed the motions limit either, but obviously you can't collaterally attack a restraining order in a trial. Just making sure that's known as well. That's all.
And she's nodding her head. She understands.
Yes, sorry.
Mr. Feliski, anything that you want to address right now here today?
I believe that is everything I have to address. The defense was not planning on calling witnesses.
That's fine. All right. Then if that's it, we will see you August 20th. Be here again, no later than 8 o'clock unless specifically requested otherwise by your counsel. Okay?
Thank you.
All right. We'll see you then. We are adjourned.
All right, let's talk about that. The final pretrial hearing in State of Wisconsin v. Victoria Mott was a textbook example of a defendant respectfully asserting her right to trial, while the court, led by Judge Mogen, ensured that everyone knew exactly what was at stake. There was no shouting, no drama, just a clear, methodical walkthrough of what comes next, and it made for a surprisingly engaging procedural moment. Miss Mott appeared in person with her attorney, Joel Felishek, and the state was represented by District Attorney Kevin Schmidt. The offer from the state was straightforward. Plead guilty to one count of violating a harassment injunction, dismiss and read in the other 5 counts, including a traffic citation, with a joint recommendation for 1 year of probation, court costs, and strict no-contact terms. Pretty standard, given the 6 total charges involved. But Mott made it clear she's going to trial. What followed was a masterclass in informed consent courtroom style. Judge Mogen walked Miss Mott through everything. The charges, 6 counts across 3 dates. The maximum possible penalties, up to 9 months per count, totaling 54 months and $60,000 in fines. And what dismissed and read in actually means. She emphasized that if the case goes to a jury and there's a guilty verdict on any count, the court could revoke bond immediately, resulting in pre-sentencing custody. The message was clear. Make this choice with eyes wide open. Miss Mott listened, acknowledged each risk, and still rejected the offer. Calm, steady, and direct. There was no theatrics, just a person standing her ground. Then came the procedural fine-tuning. Judge Mogen noted that today was the final deadline for accepting a plea. After this, it's trial or nothing. No deals. She also clarified the limits of defense strategy. No alibi notice had been filed, meaning Miss Mott can't argue, I wasn't there, or pin it on a third party. Additionally, the defense's motion to exclude video evidence without a hearing was struck as boilerplate. Mr. Felishek acknowledged that it wasn't being pursued. Finally, the judge confirmed that the defense won't be calling witnesses, which means cross-examination and Miss Mott's own potential testimony are the only defense routes on the table. Throughout, Judge Mogen was as sharp as ever, making sure each legal turn was handled with fairness and clarity. She checked every box, but did so with the tone of a judge who respects the process and the people in front of her, not just the paperwork. So now we're set for a 2-day trial starting the 20th of August. The courtroom doors are closed to further negotiations, and the stakes are real. Whether Miss Mott's defense strategy pays off remains to be seen, but she walked into this decision fully informed, and that's all a court can ask for. If you found this hearing insightful, consider subscribing. hitting the bell, and letting me know your thoughts in the comments below. I read every one.